Well, good morning, everyone. Good morning. Heard on the radio this morning on the way in, they were sharing a couple stories about how flying used to be different. And I remember my first time flying, I was sitting in my uncle's lap and he kept encouraging me to hit the call button so the flight attendant would come down. And that was still an age where you could also sit up in the cockpit. And I was able to get my golden wings from the airline pilot at the end of the flight. And sadly, that doesn't happen anymore. But made me think of a question that I wanted to ask everyone here this morning and see if you ever thought about it. Anyone here ever think about jumping out of an airplane?
Yes, I've done it.
Done it? All right. That's with a parachute. Ken, would you do it?
No.
For $1 million, would you do it?
Yes.
If you do it for free,
Yeah, you get my way.
pay your way. Well, Ken really sunk down out of the water because he's supposed to say no, and then I was supposed to follow up and say, well, what if the airplane was on the ground? Ooh. All right. My point there is, at the end of the day, I want us all to be thinking about know the facts before you automatically assume to a question or to something that is being posited to you. So the theme this morning for a couple different things that I want to share with you is know the facts. Number one, there's a title tip that I want to share with you this morning. More and more you may be encountering folks who have land that is in a trust. Unfortunately, the trust is not located in a binder at the county building. The trust is not located in a binder that is at the courthouse. The title company cannot just go to those places and obtain a copy of the trust. No, if your client says my property is in a trust, they need to produce a copy of that trust to the title company. In addition, the title company needs to evaluate, and they might include me on that, as to whether or not the trust allows for a power of attorney to represent the trustee. So when you get into a property that is owned by a trust, make sure you get a copy of that trust document. If you have questions, give me a buzz, talk to the title company so that we can evaluate whether or not the person that is saying to you, hey, I own this property or I represent the trust, can actually do so. Number two, the second update that I want to give is we talked about last time, MRED has swapped over to 48 hours upon obtaining a new listing to either get that listing into the MLS or into the private listing network. Please make sure that is happening. They're on the lookout. In addition, in talking to Bruce Ann, Ganayar is also taking a closer look at that 72 business hours. So if you have a new listing, you have 72 business hours to get it into the MLS. If your client chooses to withhold it from the MLS for a period of time, Ganayar has their own form that they suggest you use, or I would suggest instead you use an amendment to the listing contract that just illustrates that you can withhold that property from the MLS for a period of time for a stated date. Local MLS is taking a harder look at that and they're finding folks if they do not submit that to, is it Tiffany, Bruceanne? To Tiffany over at Ganayar. Number three, buyer-broker contract. I spent a lot of hot air last meeting talking about the buyer-broker contract and the necessity of it. It is important. I've heard several stories about how people are utilizing it to secure a buyer, to secure a higher commission, but it's my understanding there's also some confusion about the buyer-broker contract. If you do not have a buyer-broker contract with your buyer and the other side is only offering, say, 2% to the buyer side, you cannot negotiate for additional commission. But if you do have a buyer-broker contract with your buyer and the opposing side is only offering 1%, $1, 2%, and you want to negotiate for that additional percentage or more, if you have the buyer-broker contract set in place, then you can utilize the purchase agreement as a tool, as a vehicle to negotiate for additional compensation on the buy side. So it's only if you have an actual buyer-broker contract set in place that you can use the purchase agreement for that. Number four, Tim.
Can we just clarify? It's technically the buyer can then ask the seller to pay their obligation. So it's not us that's doing it.
Bingo.
It is the buyer that is asking the seller to pay their obligation to their buyer.
Correct. And that's where when you have that privity, what's called privity of contract with the buyer, that enables the buyer to then negotiate for that with the seller, but only if you have that privity of contract. So keep that in mind. We had a story in the last month where a small little brokerage on their side said, what? really? What kind of shenanigans are you trying to pull off here? And it was just explained to them, well, no, we're under contract and they have a duty, so would your seller please raise their commission? And they did. Fourth item to talk about this morning, knowing the facts, fraud. It's been a while since we talked about it. In the last month, there was again a very big story out of Massachusetts regarding wire fraud. Ted Williams, a gentleman, received an email requesting that he wire his $300,000 for purchase of a condo. He had just been in communication with the title company literally minutes before, received another email communication literally minutes later with the wiring instructions, called his bank, they sent the 300 grand out the window, and it was gone.
Oh.
I cannot stress enough. If it happens in Massachusetts, it happens in Nevada. If it happens in Nevada, it's going to happen in Indiana. If it happens in Indiana, it's going to happen in Illinois. Please be careful. Start the conversation, not the week of closing. Educate the buyer, educate the seller at the start of the relationship. Please, at the start of the relationship and all the way throughout. Last item, when it comes to knowing the facts, surveys. Please do not consider surveys to be an afterthought. Surveys should be something that you have a conversation with your clients at the forefront. What do I mean by that? People go for years, people go for generations thinking that the fence line is the line of the property. That the cul-de-sac that's right in front of their house is a public road and it's not owned by somebody else, and suddenly a more astute agent comes along and takes a look at it and says, well, wait a minute, we've got an easement problem. I encourage everyone, at least preliminarily, take a look at the GIS to just see if perhaps you may have an easement issue when it comes to a property. The title company does not go online, does not look at the surveys and assess whether or not there is an issue. The title company looks for what items are of record, are recorded against the property. So encourage your clients to buy a survey. At a minimum, encourage them to obtain a copy of the previously used survey, but be mindful of the fact that if your client obtains a survey that was previously issued, and that was not issued to them, but issued perhaps to the previous buyer, since there's no privity of contract between them and the survey company, if that survey is wrong, they can't go back and sue that survey company. It's only if that contract, if that survey is updated to them. So while I see a lot of, I want the last survey that's been obtained, it's worth the extra couple $100 to have it updated so that it's directly to them, so that there's a contractual relationship between them and the surveyor, so that they can state, I can rely on. There's a lot of lawsuits out there where say, well, I relied on the survey, but if there's no privy of contract between them and the surveyor, then they can't make that claim.
Is that true if the seller's paying for that survey or the buyer?
At that point, yeah, because it's being made to induce them, so at that point they would be able to.
Okay.
Their name's going to be on it, but you're going to have to fall back relationship to contractual. They were obligated to pay for it, but the intention was for Nathan Viss or for Ted Barnes. Good question. At a minimum, we have a waiver form, so if they say no, I don't want it, please have them sign off on that waiver form. It's protecting your backside, it's protecting the company's backside, and if something comes up down the road, you can come back and say, I told you so. Also, if the survey is ordered, please make sure it is looked at before closing. I know a lot of things happen last minute, that's fine, but at a minimum, please look at that closing, whether it's a minute before, an hour before, a day before. Make sure that survey gets in, you've taken a look at it with your client, and it's not just coming in and being stored in the record books. The purpose is to take a look at it and verify what is or is not there. So, those are my legal update title tips for this morning. Keep at it, you're all doing a great job. Thanks for the questions that come in. And again, if there's anything that you see that's out there that you want me to comment on, to the entire company, to the agents that you think is important, please reach out to myself or to Rachel. Thanks.